Welcome to the Bond Dickinson Employment Law Podcast for July 2013. I'm Karen Plumley-Jones and I'm one of the practice development lawyers for the Bond Dickinson Employment team. In this podcast, I'll tell you about some of the major cases that have been reported recently, dealing with equal pay, TUPE, collective redundancy consultation and unfair dismissal. Then I'll update you on the 29th of July employment law changes. Lastly, I'll look at some employment law news stories and give you some action points to take away with you. You can pause this podcast and print a copy of the slides so that you can take notes if you wish. This podcast qualifies for CPD points and counts as non-accredited training, which means that you can claim for the amount of time you spend listening to it. I'm going to start by looking at a case in the Supreme Court called North and Others and Dumfries and Galloway Council. In this case, the court had to consider whether female school workers and male manual workers who were employed by the same employer at different establishments were in the same employment for equal pay purposes. The men were entitled to substantial bonus payments or supplements on top of their basic pay, whereas the women were not. To succeed in an equal pay claim, a claimant has to show that an employee of the opposite sex in the same employment enjoys more favourable terms and conditions. If the claimant and comparator are employed at different establishments, that is, different workplaces, the claimant can only succeed if common terms and conditions are observed at both workplaces for the relevant employees. But what's the position if there's no one employed in the comparator's role at the claimant's place of work? The claimant has to establish that, if employed at her workplace, the comparator would be employed on comparable terms to those working for the same employer in a broadly similar role at other workplaces. The issue in this case was whether the claimants had to show there was a real possibility that someone in the comparator's roles could be employed at their workplace. The Supreme Court permitted the claims to be brought. Lady Hale confirmed that the correct approach involved considering the terms on which the comparators would be employed if they were employed at the claimant's workplace. The evidence from the Council's Group Manager of Human Resources confirmed that, although he could not envisage it happening, in the event that the comparators were based in schools, then they would retain their conditions. The case will now return to the tribunal to decide whether the claimant's work is of equal value to that of the comparators, and, if so, whether the Council has any material factor defence it can rely on to defeat the claims. This decision will have an impact on employers who operate from different locations, as it will be easier for an employee to mount an equal pay challenge despite being unable to identify a comparator at his or her particular workplace. In my second case, Seaver Freight UK Limited and Seawell Limited, the Court of Session considered the service provision change test under TUPE. Mr. Moffat was employed by Seaver as a logistics coordinator in its warehouse. The workforce was organised into two separate parts, one for inbound goods and one for outbound goods. Mr. Moffat worked in the outbound group, which consisted of 8 employees. He spent all of his time working on the Seawell account, and his job description stated that he had been employed for the purpose of enabling the Seawell contract to be performed. Other employees spent part of their time doing Seawell work. Seawell decided to bring the work back in-house. Mr. Moffat's employment was terminated, and he claimed unfair dismissal and breach of the TUPE information and consultation obligations against Seaver and Seawell. An employment tribunal held that he had transferred to Seawell, which was liable for unfair dismissal. Seawell appealed. The Inner House of the Court of Session held that Mr. Moffat was not an organised grouping of employees, so the conditions for a service provision change under Regulation 3(1)b of TUPE had not been met. The Court endorsed the view expressed by the EAT in Eddie Stobart Limited and Mormon and others, that the concept of an organised grouping implies that there is an element of conscious organisation by the employer of his employees into a grouping or team that has as its principal purpose the carrying out of the relevant activities. At the Seaver site, the activities were organised not by client but by type of service. It could not be said that any particular group of employees was organised to have as its principal purpose the carrying out of activities for Seawell, as they did similar tasks for other clients or customers. It was wrong to say that because Mr. Moffat spent 100% of his time on the Sewell contract, he amounted to an organised grouping. The fact that his job description mentioned Sewell did not change this analysis. The service provision change provisions are due to be repealed as part of the TUPE reforms, but it is likely that there will be a long lead-in period before this change takes effect, so the authorities on service provision changes will be relevant for some time. Should TULRECA be rewritten to make it consistent with the Collective Redundancies Directive? This was the question before the EAT in Usdaw and Ethel Austin Limited in administration, and another case. Where an employer proposes to make large-scale redundancies of 20 or more employees at one establishment within a period of 90 days or less, it must consult on its proposal with representatives of the affected employees. The maximum sanction for breaching the obligations is a protective award of up to 90 days gross actual pay for each affected employee. The relevant legislation is Section 188 of TULRECA, which implements the European Collective Redundancies Directive. The UK law and the directive differ in some important respects, and this case highlights one of them. Woolworths and Ethel Austin went into administration. Each had a head office and shops of varying sizes. The administrators did not consult collectively, and Usdaw, the trade union, brought claims for protective awards. In both cases, the tribunal held that each store was a separate establishment under TULRECA, so there was no need to consult collectively at stores with fewer than 20 employees. The head office employees and those at stores employing 20 or more employees received protective awards, but over 4,000 employees at stores with fewer than 20 employees did not. The Woolworths employees received 60 days' pay each, and the Ethel Austin employees received 90 days' pay. Usdaw appealed against both decisions. The EAT allowed the appeal and decided that UK law does not uphold the directive's core objective of protecting workers' rights. It held that Section 188 of TULRECA was inconsistent with the Collective Redundancies Directive. There was no mention of "at one establishment" in the directive, so those words needed to be deleted. The EAT did not see the need to refer the case to the ECJ, although the Northern Ireland Industrial Tribunal has recently referred the same issue to the ECJ. BIS is seeking leave to appeal against the EAT decision, and we will have to see what happens next. For the time being, any organisation making at least 20 redundancies over 90 days must carry out collective consultation, even if there are fewer than 20 employees at any of the places of work. It may be difficult to know if the threshold is reached if there is no central HR, and a system will be required to monitor this. Employers should review ongoing redundancy programmes in case they need to start collective consultation. My last case this month is City and County of Swansea and Gale, which looked at whether an employer's use of covert surveillance rendered a dismissal unfair. Mr. Gale was employed by the council. He was seen by a colleague playing squash at the local sports centre when he should have been at work. About a month later, he was seen again at the sports centre during working hours. The council engaged a private investigator, who covertly filmed Mr. Gale outside the sports centre on 5 subsequent occasions during working hours. The council dismissed Mr. Gale, and he brought a number of claims, including unfair dismissal. The Employment Tribunal upheld his unfair dismissal claim, but awarded no compensation on the basis of contributory fault. The council appealed. The EAT allowed the appeal and overturned the tribunal's decision. The council's actions in arranging covert surveillance did not affect the reasonableness of its investigation into the employee's misconduct. The tribunal had wrongly concluded that filming the employee in a public place breached Article 8 of the European Convention on Human Rights, the right to respect for private and family life, and the employer's obligations under the Data Protection Act 1998. The EAT confirmed that an employee has no right to privacy when defrauding his employer. This decision does not suggest that covert surveillance as part of a disciplinary investigation will always be reasonable. It will be rare for covert monitoring of workers to be justified. It should therefore only be used in exceptional circumstances, and not in places that employees would normally expect to be private. Next, I'm going to go through the 29th of July employment law changes, focusing on the new Employment Tribunal fees and rules. The new fees regime will apply to tribunals and the EAT, although fees won't apply where the ET1 or Notice of Appeal was submitted before the 29th of July. There are two types of cases, Type A and Type B. Type A cases are the more straightforward claims and are mainly for sums due on termination, such as unpaid wages, payments in lieu of notice, and redundancy payments, but also including equal pay claims. Type B cases are everything else, such as unfair dismissal, discrimination, and whistleblowing. The issue fee will be £160 for Type A cases and £250 for Type B cases, and the hearing fee will be £230 or £950. In the EAT, the appeal fee will be £400 and the hearing fee £1,200. If two claims are made, such as for a redundancy payment and unfair dismissal, the claimant has to pay the fee for the highest level of claim. There are higher fees for multiple claimants, for example, in an equal pay claim. A new remission scheme will apply to unemployed claimants and those with low incomes, where the fee may be waived or reduced. The ET1 has to be accompanied by the fee or a remission application. If this isn't done, the claim form will be rejected. If the remission application is unsuccessful or no fee is paid, the tribunal will write and ask the claimant to pay the fee. The ET1 will be sent to the respondent when the fee is paid or the remission application is made. This means that respondents may have to start preparing their ET3 before a decision on the remission application is reached. If the hearing fee is not paid by the date stated, the tribunal will write to the claimant giving a deadline for payment. If it's not paid, the claim will be dismissed, but there is discretion to reinstate it. Respondents may have to start preparing for a hearing before they know whether the hearing fee has been paid. The employer will have to pay £160 for a breach of contract counterclaim and £600 for judicial mediation. The tribunal has a discretionary power to order the losing party to reimburse the successful party's fees. The new tribunal rules will apply to all cases from the 29th of July, not just cases issued after that date. They are shorter and clearer than the 2004 rules and should enable cases to be dealt with more efficiently. The overriding objective is to enable tribunals to deal with cases fairly and justly. New ET1 and ET3 forms will have to be used from the 29th of July, and the most important change is that the claimant will have to specify what compensation he is seeking and how he has calculated it. A paper sift will be done when the ET1 and ET3 have been filed. The judge will consider whether there are arguable complaints and defences within the jurisdiction of the tribunal, and can dismiss all or part of a claim or response if it has no reasonable prospects of success, including where a claim is in a form that can't sensibly be responded to. The judge will also order directions at this stage. Case management discussions and pre-hearing reviews will be combined and renamed preliminary hearings. Deposit orders can be made as a condition of the party continuing with any weak allegation or argument in his claim or response. This will also apply to respondents. It looks as if the deposit will have to be paid to the other party if they are successful. You will see some changes at hearings. Witnesses may be excluded from the hearing until they have given their evidence. Witness statements will be available to the public for inspection in the hearing room, and the judge will be able to impose a timetable at hearings and set time limits, such as for questioning and cross-examination of witnesses and making submissions. The judge will be able to stop parties or their representatives going beyond these time limits. Until the new fees and rules have been in place for a few months, we won't know what their impact will be, but we think there will be fewer claims after the 29th of July. It's likely that the fees regime will deter nuisance claims, and low-value claims are less likely to be brought, but there will be little impact on serious claims, such as those for discrimination and whistleblowing. Difficult claimants will probably not be put off by the fees. As a result of the weeding out of claims, it's likely that those that are issued will be more likely to succeed and potentially more costly for employers. If judges carry out the sift properly, it's possible that more claims will be thrown out early in the proceedings, but the hurdle may be quite high, and we're not convinced that judges will dismiss claims at an early stage. We're likely to see more preliminary hearings in order to deal with issues before the final hearing, and final hearings will be shorter if judges exercise their timetabling powers. When negotiating a settlement, claimants are likely to want to recover any fees they have paid, so this could add up to £1,200 to settlements. Overall, the effect on employers will depend on the approach taken by judges and how proactive and robust they are in managing cases. Compromise agreements will be renamed settlement agreements from the 29th of July, when confidential pre-termination negotiations come into force. This provides a statutory framework in which certain discussions between employers and employees can be kept confidential from a tribunal for the purposes of most unfair dismissal claims. An ACAS Code of Conduct will come into force on the same date, and ACAS guidance will be available before the end of July. The limit on compensatory awards will be the lower of £74,200 or 52 weeks' pay, where the effective date of termination is on or after the 29th of July. Some changes will be made to interest on tribunal awards on the 29th of July, which means that interest payable on a claimant's losses up to judgment as part of compensation for discrimination will be increased from 0.5% to 8%, and interest on a tribunal award will accrue from the day after the relevant decision, unless the full amount is paid within 14 days. And now some employment law news items. ACAS early conciliation is intended to commence in April 2014. Following publication of its consultation paper in January 2013, the government has considered the various submissions it received and has now published its response, which gives more detail as to how early conciliation will work in practice. The government has also published its proposals on reservists following a consultation exercise. It plans to legislate so that reservists will be able to claim unfair dismissal without a qualifying period, where they are dismissed for reasons relating to their reserve service. The government also intends to revise the financial support available to employers in respect of employees who have been mobilised. It's unclear when these proposals are likely to be implemented. Croatia joined the EU on the 1st of July, and the government is applying transitional restrictions on Croatian nationals' access to the labour market. A Croatian national may require an accession worker authorisation document to work in the UK, and it's an offence for an employer to knowingly employ someone who doesn't have this document or works in breach of any conditions. An employer can be fined up to £5,000 per worker. There are several action points that you should consider as a result of the matters I've covered in this podcast. If you're proposing to make 20 or more redundancies in 90 days or less, you will need to carry out collective consultation no matter where the roles are based. Ensure you have a central system for keeping track of the number of redundancies being made in the organisation, and review any ongoing programmes, as collective consultation may now be required. If you're considering using covert surveillance on an employee, ensure that there are exceptional circumstances, and the surveillance only takes place in public places. Consider what your strategy will be in tribunal claims in light of the new fees and rules, and if you use your own standard compromise agreement, rename it settlement agreement and amend any references to compromise agreements in your precedent and other documents. I hope you found this podcast useful. Please get in touch with your usual Bond Dickinson contact if you have any queries. I'll be back in September. Thank you for listening.